Welcome to Q&A practice. We'll start out with plaintiff attorney. Ready? Here we go. Did you ask her if defendant was wearing his uniform when it happened? I did not ask that, no. Did you ask her if she was scared that she might get arrested if she didn't comply with an officer wearing his uniform? No, I did not ask her that. Okay, why? Because those questions would be more suited asked by the detectives in a controlled environment. All right, and did that eventually occur if you're aware? Yes, it did. All right, nothing further. All right, additional questions on behalf of defense. Just a moment, Your Honor. All right. Nothing further, Your Honor. May this witness be excused, or does he need to be subject to recall? Gentlemen, excused, subject to recall. You know what that means, Sergeant? Yes, Your Honor. All right, sir, you may step down at this time. Thank you. You're welcome. All right, ladies and gentlemen, we are going to break early today for lunch. I'll see you back at 1:30. Remember my prior admonition to you not to form or express any opinions on this, nor to discuss any issue related to it until such time as it is finally submitted to you for your deliberations. I'll see you back in this courtroom at 1:30 p.m. All right, counsel, I'd assume your next witness was Ann Trask. That's correct. I had some conversations with Deputy Elliott earlier, and he indicated it would take at least 15 minutes to get her over here. I told him to have her brought over after lunch, I think. Can we get her over here at 1:15? Probably should ask the jury to meet at the other place, but there's only so much I can do, counsel. I understand. I appreciate it. That will do. Thanks very much. Thanks, Bill. All right, let's go back on the record in People versus Borden. All parties are present, represented as before. We are outside the presence of the jury. We just conducted a chambers conference in which counsel brought to my attention some impeachment information that they wanted my rulings on as to whether or not it could be gone into. The information that was brought to my attention was a 1995 shoplifting and false information to a police officer, crimes that may have occurred out of state. 2003, 3 different offenses. One is a petty with a prior, the other is a vehicle theft pursuant to 10851, and the last is a 211 robbery, and then a 2005 offense for attempted grand theft within the meaning of 66487 of the Penal Code. The court's ruling, when asked to rule on these in chambers, was that neither side would be allowed to inquire into the 1995 prior criminality, but both sides would inquire into the 2001 through 2005 criminality. Does that correctly set forth the discussion we had in chambers? Yes, Your Honor. The conduct is appropriate regarding the $80,000 course of conduct. Just to be clear, we are not to go into the 1995 stuff. That's correct, without further order of the court. Okay, all right, we are back on the record in People versus Borden. All parties are present, represented as before. All members of the jury and both alternates are present. Mr. Randolph, you may call your next witness. Thank you, Your Honor. The people call Ann Trask to the stand. All right, you do solemnly state that the evidence you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, I will. Thank you. You may be seated. Please state your name for the record, spelling your name. Ann Trask, T-R-A-S-K. Ladies and gentlemen, as I instructed you before, you probably have noticed that there's a deputy sitting up next to the witness. As I instructed you before, this is not something you're to take any cues from. It doesn't matter which side calls a witness. If a witness is in custody, the sheriff's policy is that they will have a deputy seated next to them during their testimony. Everyone understand? All right. And how do you pronounce your last name? Ann Trask. Have you ever testified before? No, ma'am. No, sir. Thank you for the no, sir. Let me go over some of the rules in the courtroom so you don't get frustrated while you're up here. Please try not to say uh-huh or uh-uh. The reason for that is it's difficult for us to know whether you're trying to say yes or no. It's also extremely difficult for the lady seated in front of you to take down what you're saying because they sound so close together. It's okay to nod your head for yes or shake your head from side to side for no, as long as you say something as well. I need to have something said out loud. The reason for that is the court reporter has to take down what's said. She has to take down everything that's said in the courtroom. She can't take down a nod of the head or shake of the head. The microphone in front of you is a good friend. It's not an enemy. If you can get it closer to you, it will be much easier to hear your answers. The next rule is this. This is the one that gets people into the most trouble. Please try not to speak at the same time that the attorneys are speaking. You're going to hear their questions, and especially if you're nervous and you don't want to be here, when you think you know where they're going, you'll want to spit the answer out so you can be done with this. It will actually slow things down, okay? Wait for them to complete their question and give them about a second, because sometimes they pause a little in the middle of their questions. Give them about a second and then go ahead and answer the question. Understand? Yes, sir. If you don't hear their question, let us know that you didn't hear it, and they'll ask the question more loudly. If you don't understand the question, let us know you didn't understand it, and hopefully they'll be able to ask a more understandable question. Do you understand? Yes, sir. All right. If you hear the word objection from either side, please stop talking. I have to rule on that objection. Once I've ruled on it, the attorneys will either ask you to answer the question or they'll ask you a new question. Do your best to only answer the questions that they ask. They're going to be doing their best to ask very specific questions, so try not to just volunteer information, and that requires you to listen closely to the questions that they ask. Let me give you an example of how this causes problems. Do you know what time it is? Yes, I do. Okay, you did exactly what you're supposed to do. You looked up at the clock. I tried to bait you a little bit, so get you to do what most people do, which is volunteer the time. You answered my question, which is, do you know? Whenever you hear a question that sounds like, do you know, or do you remember, those generally should be answered by a yes or no, or I'm not certain, okay? Yes. Let's see. Ready? Here we go. That's a lesser standard than beyond a reasonable doubt. What we're here for, right? Correct. Objection, argumentative, sustained, motion to strike, granted. Just to be clear, is it your testimony that you did not have enough to arrest Ann Rogers that night? I'm going to say yes, that you did not have enough. Is that your testimony? Yes, I didn't arrest her because I was told not to, so that's what you're basing it on. That's my testimony. That's what I'm saying. I see nothing further. All right. No further, Your Honor. May this witness be excused or subject to recall. Subject to recall. Do you know what subject to recall means? Meaning they can call me back. Yes, you'll still be under the same oath. I'm not releasing you. I'm allowing you to step down at this time. Am I good to go home, though, for today? Yes, thank you. Call Officer Nelson. You do solemnly state that the evidence you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir, I do. Thank you. You may be seated. Please state your name for the record, spelling both. Robert Nelson, R-O-B-E-R-T. Last is N-E-L-S-O-N. Mr. Nelson, are you a police officer? Yes, sir. Have you testified in a courtroom before? Yes, sir. You're familiar with the rules for testifying? Yes, sir. You may examine. Thank you. You're welcome. That was a short one. Let's see what else we have. few minutes, so another short one. Ready? Here we go. What did the detective tell him, if anything? He said that he agreed with me. Objection, Your Honor, that calls for hearsay. What the detective said, it goes to the effect on the, just a second, is it offered for the truth of the matter? No, ladies and gentlemen, there's a subject of hearsay. I talked to you a little bit about it yesterday. Sometimes I think it's important that you understand that what it is that I'm ruling on and what the reason for the objection is, what hearsay is. In a court, hearsay is objectionable under the circumstances that it is a statement that is made out of court offered for the truth of the matter asserted. And what does that mean? Well, obviously, if something's said at the sheriff's department an earlier time, it's not a statement that was made here in the courtroom. That's easy. For the truth of the matter asserted means that you are expected to perhaps take as true that which somebody might have said. If we don't care whether it's true or not, then it's not going to be objectionable hearsay for the purposes of our trial. An example would be, let's say that we are in a crowded theater and someone yells fire. Do you think it matters if it's true that something is on fire? Or do you think that people are going to jump up and rush to the exit? So that is what is probably going to happen, and whether it's true or not, it doesn't matter. In this case, if the sheriff's office said something to Mr. Arnold like, I don't know what it's going to be, but it has to do with that shed. If someone did do that, it wouldn't matter if that statement was true or not. So what we are interested in is the effect on the hearer, like the person in a theater hears fire, and we get the explanation of why we ran. That is not hearsay. Overruled, Mr. West. Okay, you can answer. Why don't you read the question back? Second objection, please, Your Honor, is irrelevant. Her state of mind is irrelevant. Her state of mind is not the issue. I'm going to overrule the objection. Thank you. You're welcome. And we will stop there. That will conclude our Q&A practice.